Hello and welcome to another episode of Legal Curiosity. I hope you guys are safe and healthy. Today we have come up with a topic that is more technical and will be actually more relevant for students. Today we'll be discussing on force majeure, one of the most common topics of discussion since the beginning of the COVID-19 pandemic. We have tried to make you understand the topic from a legal viewpoint in the most simplest form. You will be hearing a new voice today. She has worked really hard to make this topic really simple for you. Please treat her well.
Hello everyone. So the topics we will be covering today are: first, introduction; second, what does it include; third, why is this concept important for businesses; fourth, consequences of force majeure event; fifth, what if a contract does not include a force majeure clause? Sixth, does a government announcing force majeure freeze a party from its contractual obligation? Then we will move on to the seventh topic, that is force majeure versus pacta sunt servanda. Then we will see the eighth topic, that is the frustration of a contract. The ninth, difference between frustration of a contract and force majeure and its example. 10th, areas where force majeure may not be enforceable. And lastly, we will have a brief recap of all the topics learned. So let's start. What is force majeure? It refers to a clause that is included in a contract between parties to remove the liability for natural and unavoidable disasters that have the ability to hinder the expected course of events and which also may stop parties from fulfilling their obligations. Now, no party can be held accountable as it is considered as an act of God. In order to call an occurrence as force majeure, the situation must be unforeseeable, external to the parties to the contract, and lastly should be unavoidable. Only then an event will be declared as force majeure and it will be applied according to this jurisdiction. Now, what does it include? It includes an act of war, whether declared or not, hostilities, invasion, act of foreign enemies, terrorism or civil disorder. Then it also includes disease outbreak, epidemic or pandemic, since these have the capability to halt business transactions. Next we have tempest, earthquake or any other natural disaster of overwhelming proportions, and lastly any other unforeseeable circumstances which is beyond the control of the parties. Now, beyond the control of parties means something which would have been unreasonable for the affected party to take precautions and which the affected party cannot avoid even by using its best efforts, thus causing either party to be unable to comply with all or a material part of its obligations under the agreement. Now let's move forward to the next topic, that is, why is this concept important for businesses? Now, force majeure clauses can usually be found in various contracts such as power purchase agreements, supply contracts, manufacturing contracts, distribution agreements, project finance agreements, agreements between real estate developers and home buyers, etc. This provision is important for businesses as it relieves the parties from performing their respective obligations which are to be undertaken under the contract and its consequential liabilities during the period when force majeure events continue, provided that the conditions for clause to become applicable which have been discussed above are met duly. Consequences of force majeure event. First, suspension. It refers to suspension of rights and obligations for the duration of the force majeure event for either or both the parties. Now this grants the affected party an extension of time for performance until the event impacting its ability to do so ceases. However, the party should check how soon after the force majeure event the affected party is required to resume performance. For example, due to the ongoing COVID-19 measures, many manufacturing plants were closed down. Because of this, it may take a considerable amount to return to previous level of production even after measures are relaxed. Thus, the affected party may not be able to immediately return to fulfilling its contract and will continue to require relief beyond the official lockdown. The second consequence is of that of termination. Now, depending on the contract, termination can either arise as an automatic consequence of claiming force majeure, or it may give the parties discretion to terminate, normally after a specific period of time, provided the termination requirements of the contracts must be complied with when exercising right to terminate. Third is the compensation. It is one of the major consequences of force majeure event. However, in rare case, a contract will allow the affected party to claim financial compensation from the non-affected party for costs associated with the force majeure event. And lastly, the consequence is that of negotiation. Arguably, the most challenging alternative, particularly in circumstances changing as dynamically as the COVID-19 environment, as it is an obligation for the parties to negotiate amendments to the contracts to address the impact of force majeure. Now guys, have you ever thought what if a contract does not include a force majeure clause? Well, let me tell you, the existence or absence of a force majeure clause is not the end. There are other avenues to seek relief from contractual obligations due to a force majeure event, including remedies of common law. We have the doctrine of commercial impracticability. Now, impracticability in Indian law comes under the scope of Section 56 of the Contract Act 1872, in which it has been held that an agreement to do an impossible act is void. Also, if a contract does an act which after the formation of the contract becomes impossible by the reason of some event beyond the control of the promisor, then such a contract becomes void when the said act becomes impossible or unlawful. One can go through the case of Satyabrata Ghosh versus Mugneeram Bangur. Does the government announcing force majeure frees a party from its contractual obligations? Well, as a general rule, declaration of force majeure itself does not freeze a party from its contractual obligations. Force majeure clause does not give a blanket protection against any non-fulfillment of contractual terms. It also depends on the mutually agreed upon events and obligations to be covered by this clause. But with COVID-19 outbreak being considered a natural calamity, the clause can be legally invoked. Simply said, if there is a force majeure clause in your contract, after the government declaration, you can invoke that clause. However, if it is absent, the government declaration is of little value to you. Under the Contract Act, the doctrine of frustration of a contract is envisaged in Section 56, which states that an agreement to do an act impossible in itself is void. On a plain reading of Section 56 of the Contract Act, it is evident that the section envisages some impossibility or unlawfulness of the performance of the act, which the parties had not contemplated at the time when they entered into the contract. It leads to a pertinent question as to what is such an impossible act that would lead to a frustration of a contract. Simply put, if performance of an act becomes impossible or unlawful after a contract has been executed, and such impossibility is due to an event which the party undertaking the performance could not prevent, then such contract itself becomes void, or one can say that the contract became frustrated. The courts in India have held that the word impossibility used in Section 56 of the Contract Act must be interpreted in a practical form and not in its literal sense. Thus, a contract would come under the purview of Section 56 of the Contract Act even if it is not an absolute impossibility, but the contract has fundamentally changed, which the parties had not contemplated at the time of the agreement. Now, this principle has been upheld in the case of Satyabrata Ghosh versus Mugniram Bangur and Co. and another. Now, it is pertinent to say that the concept of restitution as set out in Section 65 of the Contract Act also assumes significance in the context of the frustration of a contract. Section 65 states that when an agreement is discovered to be void, such as in case of a contract getting frustrated, the person who has received any advantage under such agreement is bound to restore it or make compensation for it from whom he received it. Thus, one of the consequences of frustration of a contract is restitution, whereby parties are to be put in the same position they were if the contract had never been executed. Let's see some difference between force majeure and frustration of a contract. The frustration of a contract is not contemplated at the time of execution of the contract, whereas in the case of force majeure, prior to the execution of a contract, parties identify an exhaustive list of events which would attract the applicability of force majeure clause. Second, frustration of a contract renders the contract void and consequently all contractual obligations of the parties cease to exist. Whereas, in the force majeure case, it results in deferment of performance of contractual obligations. It does not absolutely excuse parties from performing their obligations. And lastly, frustration of a contract may be claimed by the affected party, but force majeure is not specifically covered under a contract. Now, it is to be noted that if a particular event is covered as a force majeure event in a contract, frustration of such a contract cannot be automatically claimed. Let's see some example of frustration of a contract and force majeure with respect to COVID-19. First, we will discuss frustration of a contract's example. Let's suppose a company had entered into a contract with an event organizer to provide sound and lightings for a concert. However, due to the lockdown imposed in India, the concert can no longer take place. In this case, the contract between the company and the event organizer, Y, will be frustrated since, due to the lockdown imposed by the government, it is now impossible for the concert to take place and therefore for either party to perform its obligations, and therefore the contract will, in light of Section 56 of the Contract Act, become void, and if the event organizer has received any advance under the said contract, the event organizer will be bound to repay the advance received to the company. Now let's see the example of force majeure. Company A had entered into a supply contract for a non-essential good with Company B. Suppose such supply contract makes specific reference to occurrence of a force majeure event and consequence of the same. Let's say that the force majeure provision in the supply contract includes within its ambit any act or order of government, and upon occurrence of a force majeure event, notice of the happening of such event shall be given by either party to the other within 30 days from the date of occurrence of such event. So, consequently, obligations of Company B to supply the goods to Company A and obligation of Company A to make payments to Company B for such goods shall be deferred for a period of 6 weeks. Thus, seeing the scenario of coronavirus, the lockdown imposed by the government can be construed as an act or order of the government Company B will be required to issue a notice to Company A indicating that such an event has occurred and the lockdown is beyond the control of Company B, and therefore provisions of force majeure clause will trigger and all obligations of Company A and Company B shall be deferred for a period during which the order for lockdown continues to be in effect. Now here we are with the last topic, that is areas wherein the concept of force majeure may not be enforceable. Now force majeure is not intended to excuse negligence or other malfeasance of a party, as where non-performance is caused by the usual and natural consequences of external forces, or where the intervening circumstances are specifically contemplated. Now it would also be important to note that force majeure cannot be invoked just because the contract has become financially or commercially more difficult to perform. Thus, in order to seek reliance on a force majeure clause, a party will be required to demonstrate that the event of force majeure was beyond control of the party, that is, it has taken all responsible steps which may be commercial or financial in nature, like disbursing some additional money, hiring extra manpower to overcome or mitigate the event and its consequences, and that there are no alternate means for performing under the contract. So, what did we learn? We learned that force majeure clauses are contractual clauses which alter parties' obligations or liabilities under a contract when an extraordinary event happens. Next, we studied that it includes act of war, natural disasters, and other unforeseeable circumstances, and is important for businesses as it relieves the parties from performing their respective obligations when a force majeure event happens. Later, we studied about the force majeure that mainly leads to suspension of rights, termination of contracts, compensation claim, and negotiation. Later, we studied that in absence of a force majeure clause, common law remedy, that is the doctrine of commercial impracticability, is available. Later, we discussed about force majeure versus pacta sunt servanda. Then we studied about frustration of a contract, that is an agreement to do an act impossible in itself is void. Later, we studied about the difference between frustration of a contract and force majeure and its example in relation to COVID-19. And lastly, we studied about the areas where force majeure is not enforceable, that is when there is a malfeasance of a party or when non-performance is caused by the usual and natural consequences of external forces. This brings to an end for this episode. If you like this video, please like, share and subscribe. Thank you for watching. Bye guys.